This is the third in a series of videos providing an overview of the Wales safeguarding procedures as they relate to children at risk of harm. Running alongside this video is an additional video that will cover the content and the use of the app as it applies to Section 3, Part 1 of the procedures. Section 3, Part 1 of the Wales Safeguarding Procedures for Children at Risk covers the process and the duties in relation to responding to a report of a child at risk of abuse, neglect, and/or harm. So a reminder of the stages that have been followed up to this point. The practitioner has identified and raised a safeguarding concern, discussed this with the line manager or designated safeguarding person. From this discussion has considered another number of options and has reached the conclusion that a report about safeguarding concerns needs to be made and has subsequently been submitted to social services. Upon receipt of the safeguarding report, social services will complete some initial checks, and within the detail of the procedures, the checks that need to be undertaken are detailed, and these include checking existing records, checking the child protection register to see if the child is currently registered, to check in relation to the safety of other children in the family, and to identify what other agencies are involved or need to be involved. If social services are unable to gain sufficient information from the report maker themselves, they should contact other practitioners who may hold information on the child and their family, and you may be one of those practitioners who is subsequently contacted. Where requested to do so, you have a duty to cooperate with social services and provide any relevant information that you may have. Upon the completion of these initial checks, social services will make their initial decision within 1 working day. The process of undertaking those initial checks and discussions, however, does not simply mean a discussion directly with professionals. The procedures set out the expectations in relation to how children and families will be engaged during the initial checks and discussions. In relation to seeing the child, the procedures clearly state that the child should be seen the same day if they are reported to have sustained a physical injury, if they've disclosed physical and/or sexual abuse, and is to be returned to a situation that might place them at further risk. If the child is already subject to a child protection plan, if they are suffering from severe neglect or other severe health risks, and/or if the child has been abandoned. The child and family, or the parent, should be informed of the report that has been made, but social services will make the decision not to share that report if it will put the child at further risk of harm. Any decisions not to inform the child or parents of the report being made must be recorded. Social services must also then inform the family of any initial decision that they then make. This includes informing the family about the outcome of any report, irrespective of the outcome, informing them about how they will be informed and who will undertake this, confirming in writing, not only to the family, but also the reporting agency. And they will also, in doing so, need to make sure consideration is given to any communication, ethnicity, or cultural factors that need to be taken into account. So, in terms of making the initial decision, the procedures set out 4 options or 4 actions that social services can then reach. The first may be that there is no further action to be taken. However, consideration needs to be given to the duties under Part 2 of the Social Services and Wellbeing Act in relation to the potential role for information, advice and assistance. If the decision that is reached is that the child has needs for care and support, then social services must then initiate an assessment of care and support needs to begin as soon as the needs are identified. If the decision that is reached is in relation to a child needing immediate protection and action being required then to protect that child, then social services must make sure that the child remains in a safe place or is removed to a safe place, or it may be that a compulsory order is obtained. If there is reasonable cause to suspect a child at risk, decision 4, then a strategy, discussion or meeting then must be held. It is important to note that these 4 decision options are different to the 6 possible outcomes of the strategy discussion under the Orwell's child protection procedures. If the decision is taken by social services that no further action is to be taken, so decision option 1, the report maker still has responsibilities in terms of making sure that they communicate with the child or the family to identify whether circumstances change, so to keep that communication going. They're responsible for feeding back the need to keep regular communication with the child to any third party that may be working with or supporting the child. They should consider the information and or consider signposting to other relevant services provided, and must record in writing the decision taken and the reasons for this. A response of no further action by social services, therefore, does not deter further reports if a practitioner's concerns continue or circumstances change. What this does do, in terms of culture and practice, is emphasise the importance of being open and honest with children and parents wherever possible. If the second option is taken by social services that the child appears to have needs for care and support, they will be required to initiate their duties to undertake a care and support assessment under Part 3 of the Social Services and Wellbeing Act. The assessment process that's now undertaken under the Social Services and Wellbeing Act is primarily focused on a what matters conversation with the child and family in order to identify any care and support needs the child may have and to confirm the personal outcomes of the child. The approach to the assessment and the what matters conversation is based on these 5 elements on the screen here. All agencies working with the child will be required to contribute to the assessment if social services require their input. If the third decision is reached by social services that immediate protection and urgent action is required, then this will normally take place following an immediate strategy discussion. However, if a single agency has to act immediately in order to protect that child from any imminent danger or risk, a strategy discussion should take place as soon as possible after the emergency action has been taken. When social services or the police are taking the emergency action, they must see the child to decide how best to protect them and to determine whether to seek an emergency protection order or use any police powers of protection. Advice must be seen from the appropriate manager and legal advice obtained. And the results of these consultations, considerations and decisions must be carefully recorded in writing alongside a record of the emergency action that is taken. If the fourth option, the fourth decision is reached, that there is reasonable cause to suspect a child is at risk, then a strategy discussion or meeting must be held. The strategy discussion or meeting is the forum to share and discuss information agencies hold, to decide whether to initiate Section 47 inquiries in order to ascertain if the child is at risk of significant harm. It's the forum to establish immediate action that is required and to consider the needs and safety of other children who may be affected. During the discussion or the meeting, a determination will be reached as to whether immediate action is required legally and to determine if a child support protection plan needs to be put in place. In terms of attendance at the strategy discussion or meeting, practitioners with responsibility for child protection in police and social services must be in attendance at the strategy discussion or meeting. Other practitioners may also be required, depending on the circumstances and the situation relating to the individual child. And other practitioners could include, for example, community-based health practitioners, the consultant paediatrician, the practitioner making the report, practitioners from education, possibly third-party organisations supporting the child or the family. It is important to note that the staff involved in the strategy discussion or meeting must be authorised to make decisions on behalf of their organisation. So the strategy discussion or meeting is held within 1 working day of the decision to hold it. It can take place through a meeting, face-to-face, by phone or video conference. It may be that more than 1 strategy discussion or meeting is required, depending on the circumstances of the case. But one of the key decisions to come out of the strategy discussion or the meeting is whether Section 47 inquiries are needed in order to establish whether a child is at risk of significant harm and intervention is required. The purpose of the Section 47, as we've already established, is to determine whether the child needs protection from actual or likely significant harm, to inform any subsequent care and support protection plan that may be required to protect them from any risk and promote their well-being. The inquiry will also consider the potential needs and safety of any siblings, children or adults at risk in the household of the child, and to inform any decisions that need to be taken by both the police and social services about legal proceedings, whether these be criminal, civil or both. What is very important, and this is stressed in the procedures, and this is where we start to see a slight change in focus, a different way of approaching the 47 inquiries to maybe what we have done previously. The procedures emphasise the importance of empowering the child and the family during the Section 47 inquiries. They should be encouraged and helped to be active participants in the inquiries, unless it is inconsistent with the protection of the child. And we can help them to be active participants by treating them with respect, empathy and warmth, helping them to understand how the child protection procedures work and how they can be involved as individuals, making sure they're listened to and given time to digest and respond to the information, and making sure that they're spoken to honestly, with the power differences between the family and the practitioner recognised. And what we see are the principles of the Social Services and Wellbeing Act really start to come to the fore, particularly in relation to voice, choice and control and to co-production. We need to be actively engaging them, encouraging them to be part of the Section 47 inquiry process, because there is important information we need to gather from both parents and children. Within the procedures, it states that the information that we should be seeking to gather from parents includes an understanding of the daily lived experience of each parent or carer and how this impacts on their capacity to meet the needs of the child. Their attitude towards the child and their safety and any care and support needs. Their ability and motivation as a parent or carer to meet the needs of the child, and to consider whether there are any adult-oriented issues that are affecting their parenting capacity. It may also be relevant to gather information about any economic factors impacting on parenting capacity, but also the part played by extended family, ex and current partners in family life, and any support networks. It is also important that information is also gleaned from the child. This is more than just physically setting eyes on the child. It's about really seeing the child. And when we mean seeing the child, we mean getting an understanding of their daily lived experience from their perspective. Understanding their wishes and feelings about what they want to change. Listening to what they have to say about the cause for concern about them and their family. Observing their behaviour, appearance and demeanour, but also observing how they interact with their parents and maybe with other practitioners. It cannot be underestimated or understated the importance of understanding the child's daily lived experience. We will often hear reference to the importance of hearing the voice of the child. When we're hearing the voice of the child, what we're seeking to do is understand their child's lived experience. It's only by understanding the lives of both parents and each individual child in that family that we can begin to understand why those needs are not being met and what would need to change in order for those care and support needs to be met, in order for risks to be minimised and managed, and in order for the personal outcomes of the child to be achieved. It is important, though, that we do not pressurise children and young people into discussing their daily lived experience. We need to bear in mind that the child may well be keeping safe by not telling things to professionals. It could be that the child, through their experiences, has learned to minimise the situation and its impact. Or it could be that the child is blaming themselves for the problems and that they don't want their parents or carers to get into trouble. Therefore, some approaches, ideas as to how we can get to understand the child's daily lived experience. Start by creating a positive environment. Think about when you're going to see them, where you're going to see them, who and how long you will be there for. Explain what's happening to the child and who you are and why you're there. And aim to create that open, honest and respectful relationship from the beginning. Be mindful of other important influences on family life and try to record the actual words that they use. Capturing those words is capturing the voice of the child, is capturing their experience, not our professional interpretation of what we think the child is saying. To do this, to facilitate their engagement, to help them to contribute their views, their wishes, their feelings, their experiences, we might need to use a range of tools. Clocks, cartoons, pictures, toys, images. Be creative in that direct work that's being done with the child. Don't let them get bored because they will then disengage. But in that, recognize that some days can be more chaotic than others. So you could be visiting on a chaotic day, but actually ask the child to describe a less chaotic day. Or if you're there on a quiet, calm day, ask them to describe a chaotic day. Find out how life varies at weekends, school holidays, with different people, family members in the house. Aim to use those open questions and don't take anything for granted. while you're doing that, use your observations to understand the daily lives of children. It isn't simply going on the spoken word of the child. And don't jump to conclusions. What's important to note is developing that understanding of the child's lived experience takes time. It's not something that can be rushed. When we rush, we go to seek out the information we think we require. And it prevents us from keeping that open mind to understanding the lived experience of the child. So in addition to gaining that understanding of the child and the parent's lived experience, when undertaking then the inquiries, the information we will be gathering includes information about the incident or concerns that brought the child and their family to the attention of the agencies, as we've described the daily lived experience of the child and their carers, as well as their wishes and feelings about their lives and desired outcomes. Family members' perceptions of whatever may have occurred, their needs, worries, and strengths. Information in relation to our knowledge of the family, both past and present, from any professionals who are in contact with the family members. And also information about the family structure, network, and past family history. And again, it's helpful to come back to the model of assessment, the model of the What Matters conversation, because in particular, we will be gathering information in respect of personal circumstances and the personal outcomes. We might be getting insight into the barriers to achieving those outcomes, the strengths of the family, and any risks if those outcomes aren't achieved. Information gathering also extends to an understanding of the quality of the attachments between the children and the carers or the parents, the strengths of the family, which includes the strengths of any children, the risks to the children and the children's needs for protection, and also the ability of parents and wider family and social networks to safeguard and promote the child's welfare. And once again, we see that we will gather that information through the exploration of the assessment model and, more importantly, the What Matters conversation. In terms of the information that will be sought from partner agencies, practitioners asked to contribute to an assessment may be asked to provide further information about the child's situation and any actions or services that they feel would be of immediate benefit to ensuring the child's safety, care and support needs are met. This is not necessarily their perception of the services they think social services need to provide, but what can they contribute as an agency themselves? They'll be asked to contribute to an assessment through the provision of a chronology that outlines the agency's relevant involvement with the family. Any information past and present about the health and development of the child or children, information about parenting capacity and the adult-orientated issues of socio-economic factors, and also a summary of service involvement, but also the impact that that provision has had on the child or the family, positive or otherwise. It's important to note that any practitioner contributing to the Section 47 inquiry must ensure that parents and children are aware of the information that they have contributed to the process. This is important in ensuring not only do we avoid inaccuracies and shocks for family members when they see any reports being presented prior to or in the initial conference or any other arenas, but also to give them the opportunity to exercise their voice, to work co-productively and in an equal relationship, to make sure that the information that is being presented includes an understanding of the family's lived experience and the outcomes that they are seeking to achieve. Section 47 inquiries aren't simply an activity of gathering information. Once that information is gathered, it is essential that there is a detailed analysis of that information undertaken in order for that analysis to inform the decisions that then need to be made. We analyse the information in order to answer the question, is the child suffering or at risk of suffering significant harm? So through our analysis, we might be asking the following questions. What are the professional concerns about the care and support protection needs of the child? What are the parents' attitude towards professional concerns? Do they share or have different concerns? What strengths have been identified? And are they sufficient to ensure the child doesn't experience significant harm in the longer term? Are there any adult-orientated issues impacting on parenting capacity, and if so, how? We should also be considering the views and wishes and feelings of the children about their lived experience, but also about what they would like to see change. How is the health and well-being of the child being affected? How is the quality of their lived experience being affected? And how are socioeconomic factors impacting on the child or the family? So, the Section 47 enquiries must be conducted and concluded within 10 working days of the strategy decision to hold and undertake the inquiries. The 47 inquiry will establish whether a child is suffering or is likely to suffer significant harm and whether they require intervention to safeguard and promote their well-being. It will determine what's in the child's best interest to protect them and consider the needs of anyone else in the household, but will also inform decisions taken by both the police and social services. Within the procedures, there is the detail then of the determination that must be reached in conclusion of the Section 47 inquiry. The first determination that could be reached is that the concern is not substantiated. And if this is the case, the decision that will be reached is to conclude with no further action. In reaching this determination or this decision, there must be a record made of why the Section 47 inquiries have concluded, why the concerns are unsubstantiated, and any other actions to be taken. A no further action letter will then be sent to the family. What should be considered, however, is that there may be a need for some further or ongoing information, advice, or assistance for that family to help them to manage any challenges or issues they may be experiencing. The second determination that could be reached is that the concern is substantiated, but the child is not at continuing risk. In these circumstances, a child protection conference will not be held. A record will be made of the reasons for this decision and the names of all those involved in the decision. The next steps, however, will be for social services to conduct an assessment or to reach the decision as to whether a care and support assessment of the child's needs is appropriate. However, consideration should also be given to what support can be provided by other agencies, in addition to or as an alternative to social services. And the third determination that could be reached is that the concern of significant harm is substantiated and the child is experiencing or is at risk of harm, abuse, or neglect. In this instance, an initial child protection conference is needed. The record will be made of this decision and the names of all those involved in the decision. So to bring Section 3, Part 1 to a close, and to highlight the important points to note in relation to the shift in culture and practice. We're seeing a strong move from a focus primarily on the professional view of the child's risk and welfare to a focus on making the child safe. And in doing so, that we're shaping responses in line with the wishes of the child at risk and the family, balancing that with the professional view, ensuring that proportionate actions are taken to protect and support the child at risk. We're moving from 6 possible outcomes from the strategy discussion to 4 possible outcomes from a strategy discussion or meeting. Section 47 inquiries that were previously focused on the parent's view of the family circumstances and sometimes purely the professional's view, to Section 47 inquiries that will now gain a real insight into the child's daily lived experience, but that insight is gained from the child's perspective and experience. We no longer see Section 47 inquiries running alongside initial and/or core assessments, because since the introduction of the Social Services and Wellbeing Act, we no longer have initial and core assessments. We now see the Section 47 inquiry running alongside and concurrently with the care and support assessment, which might otherwise be referred to as the what matters conversation.